Hello everyone. We have already seen that remedies for torts can be studied under two heads: legal remedies and extra legal remedies. Legal remedies include damages, specific restitution of property, injunction, and remedies under the Constitution and other laws. Extra legal remedies include self-help, re-entry on land, recapture of goods, expulsion of trespasser, distress damage feasant, and abatement of nuisance. In the last presentation, the remedy of damages has been discussed. In this presentation, the remaining remedies, both legal and extra-legal, will be explained. Injunction, which is another legal remedy, is an order made by the court preventing a person from doing an act or acts of certain class, and if the order is violated, the person doing so will be sent to the prison for contempt of court. Injunction is granted only in cases where damages is not an adequate relief for the injury suffered by the plaintiff. Usually, an injunction is preventive rather than being prohibitive. When injunction is granted to prevent a threatened wrong, it is called quia timet injunction, that is, prevention before the event happens. In order to obtain an injunction order, the party must prove either damage or apprehension of damage involving imminent damage of substantial nature. Injunction cannot be granted in the case of torts of assault, battery, false imprisonment, and malicious prosecution. In India, the circumstances under which an injunction will be granted are contained under sections 36 to 42 of the Specific Relief Act. Injunctions may be temporary or perpetual, mandatory or prohibitory. Damages can be granted instead of or in addition to injunction. As granting injunction is at the discretion of the court may refuse to grant injunction in cases where damages are an adequate relief. What are the rules governing granting of injunction? Generally, injunctions are granted to prevent intentional violation of a right. Injunction is a discretionary remedy, but the discretion should not be exercised arbitrarily. The court has to find out if there is a genuine case between the parties and the balance of convenience if injunction is not granted. Injunction should not be granted when compensation is an adequate relief. It has to be granted only to maintain status quo, that is, the existing position should not be altered. As injunction is an equitable relief that is based on natural justice, if the plaintiff acts in an unfair or unjust manner, injunction cannot be granted. Injunction cannot be granted to prevent a person from discharging public duties. Specific restitution of property is another legal remedy. In India, specific restitution of property is a legal remedy provided under the Specific Relief Act. Under the provisions of the Act, any person dispossessed of movable or immovable property without his consent, not in due course of law, is entitled to recover the possession of such property. Here, compensation for loss cannot be correctly ascertained or compensation is not an adequate relief. Under English law, for trespass, ejectment of trespasser, and compensation for loss sustained during the period of dispossession, that is, mean profits, can be claimed. In detenue, the defendant wrongfully detains from the plaintiff goods which he is entitled to possess. An action for detenue will be available only for such articles of movable property which can be specifically recovered, seized, and delivered to the plaintiff. Tort of detenue is abolished in England. In India, action for detention of goods is provided under the Specific Relief Act. Extra-legal or extra-judicial remedies. Extra-legal remedies are remedies that can be obtained without the ordinary course of judicial proceedings. The law, in certain situations, allows a person to help himself by his own acts and strength. He can be his own judge and act in emergent situations, stop or ward off the damage. He can defend his life, liberty, and property by using reasonable and proportionate force. The extrajudicial remedies include self-help, expulsion of trespasser, recapture of goods, re-entry on land, distress damage feasant, and abatement of nuisance. Self-help is permitted to bring an end the circumstances in which he is placed. Right of private defense can be exercised to prevent a wrong, but the force used must not be unnecessary or excessive in a given situation. Where a person enters upon the land of another without the consent of the owner, or against his will, or by force or violence, he can be immediately turned out of the land by the owner by using force, without at the first instance asking him to leave. But if the entry is peacefully made, prior request to leave has to be made before ejecting him from the property. Re-entry on land. An owner dispossessed from the land or property can re-enter the same if he can do it peacefully without using force. In order to recapture his goods, a person who has been dispossessed of his goods can enter the land by acting promptly after dispossession. Previous request to surrender possession of goods has to be made to the trespasser to goods unless it is dangerous or of no use. Reasonable force and not excessive force should be used for recapture of goods. Distress damage feasant. Distress is a remedy wherein a person may take possession of the goods of another and retain them to compel performance of any duty or satisfaction of debt or demand or payment of damages for cattle trespass. Distress damage feasant is a common law remedy for recovering compensation for trespass by holding back the animal which is causing damage. In England, this remedy was abolished by the Animals Act 1971, which replaced it by the right to detain and sell the trespassing cattle. In India, the Cattle Trespass Act provides the right to distress, that is, hold back the damaging cattle. A person who releases such cattle or attempts to do so can be fined. The distrainer, however, has to provide the cattle with food and water. Finally, nuisance can be stopped or discontinued or abated by self-help not only from the land of the aggrieved party but also from another's land by entering upon it. Where overhanging branches of a tree on the neighbor's land is blocking the passage to A's house, A can enter upon the B's property to cut the branches and abate the nuisance caused by them. The force used to do this has to be reasonable. Notice has to be given before the right has to be exercised, but where entry into another's land is not necessary to remove the nuisance, notice to the wrongdoer is not necessary. When a person exercises this right and abates nuisance, he cannot subsequently claim compensation for the injury suffered due to nuisance. This, in brief, is about the various legal and extra-legal remedies available for tort. This series of 14 presentations is an attempt to give an idea about the general principles of law of torts. Thank you.